Okay, so people on Zoom see that you want to, if you got it, you'll be live streamed, so don't leave the meeting. Thanks. All right, looks like everything is going. Okay, so those of you who joined us and were interested in using the YouTube stream, that stream is now on and live. So just in case you want to leave Zoom, you may do that and see the hearing through YouTube. Otherwise, you're free to stay on Zoom. That's fine. Okay, so I think we have everything is going like we had planned. So at this point, we can start the hearing. What do you know? What are we here for now? Got everything running. What are we supposed to be doing? All right, so we'll get on the record. And I want to welcome everyone to docket 9300 DR 105, the petition of Midwest Renewable Energy Association to determine applicability of a third-party financed distributed energy resource systems. All right, I'm Michael Newmark, Administrative Law Judge for the PSC. And we are connected here, both having people in-house at the PSC hearing room and through Zoom. Like I mentioned, for people on Zoom, if you're having difficulty hearing us, let us know. We're using an alternate audio device here, so there may be issues with that. But in the meantime, or as we get started, let's start with appearances off the record. We'll start with the people in the room, and if all goes well, you'll see those people on the Zoom screen, but I want to make sure that we do recognize people in attendance. So starting on my right.
Cynthia Smith, representing the Public Service Commission.
Brad Jackson and Patrick Proctor Brown of Quarles and Brady, representing Wisconsin Utilities Association.
David Bender, representing Midwest Renewable Energy Association.
Okay, can you just move the microphone closer to you?
Kara Copeland-Ferris with the Citizens Utility Board.
All right.
Morning, Your Honor. Tim Lindell, LINDL, on behalf of Bold Solar.
All right. So let's continue through the room here, starting. I think we'll be able to hear you from there. That's fine.
Kate Phillips, representing Wisconsin Electric Power Company, Wisconsin Public Service Corporation.
Justin Chasko from Frederickson and Byron, representing the Wisconsin Electric Cooperatives Association at fair rates of the Wisconsin Bureau.
Morning, George. I'm Michael Friedrich, representing Customers First Coalition.
Richard Heineman, Boardman Clark, representing the municipal group that would be Municipal Electric Utilities of Wisconsin, Great Lakes Utilities, and WPPI Energy.
Okay. Mr. Coe.
Zach Ramirez from Wisconsin Power and Light.
Drew Carter, Wisconsin Power and Light Company.
Okay. Anyone else representing parties? Yes, there you are.
Brian Kleinmeyer with Stafford Rosenbaum, representing Madison Gas and Electric Company.
Okay. Any other parties in attendance?
Alex Tetzloff, Global 420.
Great. Okay. So just double check here. So I just wanted to, so let's note for the record. Oh yes, we also have, let's continue on with people on Zoom. So who do we have representing parties on Zoom? We can start with MREA.
Nick Heiler with MREA.
Okay, NSP.
Good morning, Your Honor. Ashman appearing on behalf of Northern States Power Company, Wisconsin.
Vote Solar.
Morning, Your Honor. Nick Hilvajaker on behalf of Vote Solar.
Customers First. Oh, you're muted.
Unmute. Good morning, everyone. Brian Rood, representing Customers First.
All right, City of Milwaukee.
Good morning. This is Tom Miller, Assistant City Attorney, representing the City of Milwaukee.
Okay, so for the munis as well. So Tim Hendrick,
Tim Heinrich, Municipal Electric Utilities of Wisconsin.
great. Also, PSC staff. Sophia Rogers. How about the WPPI?
Good morning, Your Honor. Tom Hanrahan with WPPI Energy.
Okay, IBEW 2304.
Good morning, Nate Rasmussen, Business Manager, IBW 2304.
Okay, great. That's all we have in attendance, and I just wanted to let's get on the record. So we did take appearances off the record, and I wanted to note that we do have, I think it's Walnut Way, and Conservation Corp is not in attendance. Wisconsin Electric Cooperative Association, anyone? Okay, there you go. And I believe that's our only already not in attendance. Okay,
Your Honor, this is Katie Nicola representing Clean Wisconsin.
oh, okay, I thought I, I saw you there, sorry, I thought I called that. Okay. All right, great. So we got that, appearances, and let's just take a peek at the service list. We can do that off the record. Any corrections we need to make or additions to the service list? Okay. So I wanted to note, we can do this off the record, just wanted to note that we are here for the party session, and there'll be a public hearing session November 2nd at 2 p.m. at 6 p.m. That'll be completely on Zoom. Thankful for that at this point. And so we'll be able to take public comments at that point. Currently to date, we have 19 comments filed. All right. So let's get started with our offered evidence list. Stay off the record here. So I'm going to just enlarge that. Oh, so let's get started with the offered evidence list. I shared this with parties last evening. Any additions or corrections we need to make to the filings listed? Did have some comments for refiling. Any questions about the comments?
Just have one question, Your Honor.
Yeah.
Some of our exhibits, we redacted portions of the text that allows it to search and redact rather than actually editing a document. Is that okay too, or you do want the asterisks? Because that would be editing each line or a building.
Yeah, I think that was my suggestion to hope, I played around with it and that actually killed the link, which was quite surprising. It actually worked.
But so long as it's not a live link, you're not.
If it's already a dead link, yeah, but I think I found a few that were alive, which is why I mentioned that. So
Yeah, I found some too. I just wanted to make
Okay.
sure that methodology wasn't problematic. I'll just-
oh, no, however you want to, yeah, that's fine. However, whatever works, so that would make it easier. Yeah, okay. Any other questions about the comments? No. All right, so I think we don't think the objections will relate to excusing witnesses where there's no cross. Any problems with that if we go through the witness list first and then do the motions? Will that affect people's appearances? Okay. So let's just go through our list of witnesses. So it looked like the only witness is it Hyla? Pronouncing that right? I am. Okay, the only witness for is Hyla with Cross. Any other witnesses want to appear for additional testimony?
Mr. Simon is here. We don't have additional testimony from him, but we would go ahead and verify his testimony.
Okay. Any other witnesses wish to appear? Okay, so let's get on the record and we can take, let's just note that there is no cross-examination for the following witnesses. And those witnesses may verify their filings by affidavit. I'll just list those out: Singletary, Rude, Johnson, Quackenbush, Adams, Tetzlaff, Burrows, Graves, Heiser, Simon, at the witness's discretion or the party's discretion.
Your Honor,
Yes.
you skipped Tim Heinrich. Who has 2 witnesses for the municipal-
For the
municipal group.
Okay, it's off the record. So which ones are those?
So the municipal group has 2 witnesses. One of them is Troy Adams, the other is Tim Heinrich.
Let's read back the list.
Singletary, Rude, Johnson, Quackenbush, Adams, Tetzlaff, Rose, Graves, Heiser, Simon.
Okay, so let's add to the list. So I had Adams, right? So,
Correct.
so just Heinrich,
Yes.
okay, okay. So those witnesses are excused pending verification of their filings. Of course, there is still a pending motion on the Heiser testimony, so. And let's do that now. So we do have 2 motions pending. One is to strike the Heiser rebuttal and expose affiliated exhibit, and the other is a request to accept the supplemental exhibits. So let's start with the Heiser motion at this point. So we did get a objection and motion to strike from MREA and a response from WUA. So let's have a final argument from MREA.
Sure, thank you, Your Honor. The objection is pretty straightforward. The issue is that rebuttal has to rebut the substance of direct testimony. None of the direct testimony dealt with the issue that the Heiser testimony discusses. The Heiser testimony discusses kind of the contents, the substance of a handful of consumer protection statutes and whether they apply or not. That's not responsive to anything. The UA tries to bootstrap it to 2 things. One is the petition itself, which was not direct testimony. And the other is a statement by Mr. Singletary for CUB that the consumer protection, kind of sufficiency of consumer protection is not relevant to the statutory question of the definition of a public utility. That's a different, so 30,000 foot, they both say the words consumer protection, but the substance is slightly different. There's no response to Mr. Singletary's statement about the definition of a public utility. Instead, the Heiser testimony is a whole different subject. And it's not responsive. That's so relevance aside, not proper for rebuttal. Should have come in as directed.
Okay. Response from WA?
Yes, Your Honor. I think we've set forth our arguments in our opposition, and I don't have much to add. I would just summarize that The rebuttal testimony is directly in response to direct testimony, including Mr. Singletary's position that consumer protection issues are not germane to this proceeding, that the commission should hold off and act on that at some future date. Mr. Heiser stepped in to say, hey, wait a minute. There are serious concerns of consumer protection nature, including the fact that these proposed transactions are not covered by current consumer credit finance laws. And we think that's a critical issue. It's also responsive to Mr. Hyla's characterization on behalf of MREA that these leases and PPAs that they're offering customers are quote unquote third-party financing transactions. Mr. Heiser responds emphatically that they are not, at least under definitions of Wisconsin law, and that's another critical issue. I'd finally note that similar testimony has been filed in the vote solar docket, and there's been no objection to it there. So it's, I don't think it's a close call. It's clearly rebuttal testimony in response to two pieces of direct testimony.
Okay, I was curious, any reason why this couldn't have been filed in direct?
Had we tried to anticipate every single argument that the petitioners were going to make in their direct, we did not do so. Their petition claims that these are third-party financing transactions and that current consumer laws are adequate to protect consumers. We assumed wrongly that they would address those assertions in their direct more in more detail. They did not. It was really Mr. Singletary's testimony on behalf of Cub that triggered our need to put in Mr. Heiser's testimony. We found Cub's position in this case, once we saw it, to be quite surprising in terms of the position that the commission need not or should not consider these important consumer protection issues upfront and rather to wait. And that's what triggered us to reach out to Mr. Heiser.
Okay. So I recall WUA's position in its comments, the response to the petition, and its participation at the pre-hearing conference as saying that there are many fact-based issues that it wanted to present to the commission in order to countervail what the petition was claiming. My expectation was that, and the reason why we scheduled direct simultaneously and then rebuttal simultaneously was that parties put all of their arguments in on direct and then respond and rebuttal. If one party's position on consumer protection is it's not applicable, that's that party's position. I don't see, I'm kind of having a hard time understanding why WUA didn't anticipate that, or I think it did anticipate that consumer protection was an issue, as particularly the WCA. Why that wouldn't have been indirect to allow for full rounds of briefing and discovery. A month between direct and rebuttal would have been provided for discovery on those claims from WUA. So I find it difficult to accept that WUA was justified in submitting its initial claim, initial issues of consumer protection on rebuttal, when really we did see other parties opposing the petition doing so on direct. So I don't believe it's proper to file this and introduce issues surrounding WCA in rebuttal at this time.
That's not an accurate reflection of the record, Your Honor. We addressed consumer protection issues quite thoroughly in Mr. Graves and Mr. Simon's testimony. We, again, we reviewed the direct testimony that was filed to Mr. Singletary and decided that we needed additional support in that area to rebut the idea that existing consumer protection laws are adequate at this time. And I think we're fully within our rights to do so.
Yeah, I don't agree that, I don't think you can rely on another party to be bringing up an issue that you want to present. I think
No,
that's inappropriate rebuttal.
No, we address consumer protection in our direct. Now, are we perfect in terms of anticipating every single thing we want to say in direct as opposed to rebuttal on the same issue? No, that's the point of the give and take.
But WA is the party
So
who pressed to
saying-
have a hearing and to offer
Yes.
evidence.
Yes,
And represented to me at pre-hearing conference that it had evidence to present.
and we did.
And yeah, yes. However, this issue should have been presented in direct.
It
You should-
was
Where was it presented in direct?
in Mr. Simons and Mr. Gray's testimony. Correct. The issue.
Then that's what you need to rely on for your presentation of
We're
the
not allowed
issues.
to put in any additional evidence on the issue raised in subsequent rounds of testimony. That's not the rule.
It's not how I see this. I think that this was something that the party could have anticipated, should have anticipated, presented on direct and allowed for rebuttal to take place.
We did anticipate it. We did address consumer protection.
You-
Mr. Hydra's testimony is additional testimony on the same issue.
Then on the WCA,
Is the idea that a party is not allowed to present a new witness on rebuttal or rebuttal?
that's not what
That's
I'm
common.
saying. No. that's
Well,
not
if
the
that's,
rule.
but if your position is correct, I would not be able to present a new witness on rebuttal because I can't have them say anything new on the issue that was joined in direct.
It's an issue that I believe WUA had already anticipated. For whatever reason, it didn't make it into direct. I don't know
That's
why.
not true. We address consumer protection.
Where is the WCA addressed in direct? And if it is, then that's your direct. That's why wasn't it fully addressed on direct?
Well, again, if the rule is.
Is a WCA addressed in direct? Wisconsin Consumer Act. That's the issue Heiser is raising, correct?
It's under the rubric of consumer protection. The issue is consumer protection.
So your answer is,
Was WCA mentioned in our direct? I don't believe so.
then I'm striking the rebuttal.
All right, we'll take it up with the.
Okay, absolutely. All right, so that's struck and the introduction of the Heiser one. So let's move to the WUA's request to accept supplemental exhibits. So I included in the offered evidence list the preliminary ruling because some of these seem kind of obvious, not very controversial, and I indicated what the basis for that ruling was. So let me just skip to those. So, and let me ask if there's any objections or comments on that preliminary ruling. So the exhibit that WUA has proposed to be marked as WUA 4. I denied the offer of that exhibit as duplicative of exhibit CFC Rouge 7. I think it's the same document, right? So no objection, no comments there.
No additional comments on that one. We agree it's duplicative.
So for WUA 5, I granted that document as well as WUA 6. They're granted preliminarily, but the process by which this should come to the record, I believe, should be marked as exhibit CFC routing 9 and 10, respectively. 4 and 5 should be 9 and 10, because it's the CFC witness that actually introduces the topic of those statutes, those proposed bills. And we can sort of use as a framework the idea that we're just supplementing that citation with the actual document. Any comments on that?
I just have one question. Do you expect CFC to revise that testimony at all, or is it okay that we just file it as?
Just file it as the exhibit. I think it's pretty clear.
Thank you.
Any comments on that?
Yes. I just want clarification.
Yeah, go ahead.
I think you mentioned 4 and 5 here that will be renumbered. I think it's 5 and 6.
Oh, yes, you're right. 5 and 6 will be.
So my understanding that the WUA is going to refile those with the CFC label on it.
Yes.
Okay, and then we're all stipulated that there doesn't need to be any foundation laid either in the affidavit or in revised testimony for that.
Okay.
From Mr. Ruth Park.
Well, I'll ask for any objections to that. So we can, yeah, it'll be stipulated into the record.
Okay, thank you.
Okay, so this, let me be clear. So we're going to accept what was filed as exhibit WUA 5 as exhibit CFC Route A9 and exhibit WUA 6 as exhibit CFC Route A10 to be filed by WUA. Little trickier one was WUA 7 and 8. They were letters submitted or issued by the commission in the past related to the topic of distributed DER and the definition of public utility. There is some history and background with those letters that I think aren't communicated through just the acceptance of those letters on the record. However, much of that is explained in an official statement by the commission in its order in docket. I think I typed this wrong. It's docket 9300 DR 102. That order is cited in the offered evidence list, which addresses those letters, puts them in context, and provides the commission's, I think, only official determination on the issue at hand in this case, which for me is just better evidence, better basis to show what's meant to be shown in those letters. Any objections to that or comments?
I have 2 comments to that, Your Honor.
Yeah.
So as you noted in the order from the commission, it does cite the letters, but doesn't include them and doesn't quote from them. So I think at some point we're leaving a less complete record, particularly in light of my second comment, which is both of these letters are included in the 9300 DR 106 docket as exhibits to the petition without any objection from anyone. So that was exhibit BS 10, exhibit BS 11. So I realize that these cases are not consolidated at all, but one of the reasons that we included them in our motion in this docket is they're in the other docket, so that all parties could cite it briefly. But those are my 2 comments. We don't have a strong position on including them or not. It was really more in the interest of the complete record for the commission.
I want to check the order. Is it the only comment on that?
Are you asking from anybody?
Anyone, any other comment?
On behalf of MREA, we intentionally did not include those or making reference to those 2 letters because there's history on them between MREA and the commission in some circuit court litigation. MREA challenged them as guidance documents. The commission, through its counsel, took the position that they did not reflect the commission's official actions. WUA joined that argument in the circuit court, and so to avoid having that argument again, we avoided bringing them into this case for that reason. And there's also a nuance here in that I think some of the counsel for some of the parties formerly at the commission participated in the creation of one or more of those. And if those get brought into this, then there's a question of if it becomes the same matter for purposes of the conflict rules. And so we wanted to avoid that heading as well.
Okay. Okay, well, I think since WUA doesn't have a strong position on including the letters. I'm just gonna leave the order can be cited to, it can speak for itself, and you can introduce it as an exhibit too. But that being the official determination of the commission, I think is better evidence. And it does relate to the letters, so they are cited, but I don't think they really should be brought in as authority. So we'll leave it with that. The other three documents, they were introduced as WUA 1, 2, and 3. I didn't make any preliminary rulings on that. I was interested in hearing what parties thought. So any comments on those?
Well, just your honor, to back up and explain the purpose, we wanted to make sure that we could cite these in the briefs. So these would ordinarily be legislative history documents or primary sources from the time period of the statute that we would cite in the legal brief. You know, in some circuit courts, you might have to present that as kind of non-Wisconsin authority and an affidavit. We just wanted to make sure, out of the abundance of caution, that when we're citing to what we've called the dusty books, right, the primary materials that talk about the legislative history of 1907, that we're not garnering a motion to strike, and wanted to make them available to all the parties, because some of them were hard to find, so they could cite to them equally. So that's really the intent of these three documents. They explain, you know, for instance, the first one explains the legislature's purpose behind the definition of a public utility. It's broad, right? We want to be able to cite those in briefs. So that's the purpose behind the motion.
Okay. Any comments on that?
I don't agree that they're all primary materials, but that may be just semantics. The Wisconsin legislative materials, I think they're akin to ledge council memos more recently, which I think there's case law on as a source for legislative intent. The other two, I think they are secondary materials that a party can cite for whatever persuasive value they may have. I don't have a position whether they have to be an exhibit or not for that purpose. And on all of these, we still reserve our objections on relevance to the extent, I don't know how they're going to be cited, but suspect dispute both the characterization of them in future briefs and the relevance. But beyond that, I have all the objections.
Okay. All right. So
Can I be
here-
heard?
yes, go ahead. Yeah.
Just from commission staff's perspective, this is something we struggle with too, in terms of what is law and what is accessible and what is secondary. And OGC necessarily, if the commissioners see a reference, we're going to be the ones that are trying to hunt it down. So for the convenience of the parties, especially for things that are, you know, more difficult to find, commission staff would support inclusion of that information.
Okay, great, thanks. Yeah, not hearing a strong objection and hearing support from commission staff, I think we'll allow those documents in as they are marked. And I don't know if they're properly filed. Okay, yeah, I guess I just did want to caution, because I don't see them as being primary sources. The three, well, the first one is legislative history, I believe.
Yeah, the first one is from the legislative.
Yeah.
The other two are 1907 reporting, so technically a secondary source, but
Yeah.
in the historical world, that'd be a primary authority.
So I did want to mention that they are pretty extensive. We do, of course, accept very large documents as exhibits, nothing unusual there. But they are very broad in scope. So I think it would have been helpful had these been offered through a witness, just to characterize what their intended use is for. But seeing that there's no big objections to that, I'll let them in.
Judge Nimoy, can we be heard on this?
Yeah, oh yeah, go ahead.
To the extent that you haven't already made a ruling, which you might have, I apologize for having a hard time getting off mute here, but not necessarily making an objection, but did want to observe, obviously this issue concerns the vote solar docket as well. I see the value in kind of getting ahead of the question of what can be used and cited in briefs and where materials exist. So can completely appreciate that. To the extent that these are coming in as exhibits, these are large documents. We have some concerns about the timing here. This relates to testimony that was brought in direct by WA. So I guess to us, it's not clear why these documents could not have been introduced as exhibits to direct testimony. So I guess I'll just raise that concern that from a timing perspective here, it seems like we all could have had the benefit of, looking at these documents for a few months. Not that we would necessarily have objected to them, or not that we necessarily would object to them if we had seen them in briefing, but I think that there is a timing concern.
Yeah, okay, so I think we're in agreement. We expressed the same trepidation, but yeah, I think they will be useful. I mean, who knows? Maybe we all could have come to agreement if they just gotten this document sooner. All right, so we'll accept those. I think that's all the motions we have to deal with, and
Your Honor, there's
yeah,
one additional, I guess, call it supplemental evidence issue, and that is, we have an agreement with folks with, I'm sorry, I'm mixing up my cases.
well, I understand that completely. All right, so
Strike that.
yeah, so we're ready for our first witness, our only witness. Yeah, all right, let's call our witness for,
But Your Honor,
yeah, go ahead.
did you want to address, you had in the offered evidence list, the last item?
Oh, yeah,
Question
you're right.
for Commissioner Fuller.
Thanks for reminding me, yeah, on the other page there. So I think, yeah, this is probably a statement we can hear from attorneys. And so it's a question I included in the offered evidence list. I guess initially I'd like to hear from petition opponents, and if WA wants to take the lead on that, that would be appropriate. So
Our intent, Your Honor, is to address that issue in briefing. Argument that is a matter of law and consistent with commission precedent.
okay, I'm gonna read the question first for the
I'm
record.
sorry.
Yeah. Okay. So I'm just going to read out the question for the record and get WA's response. So the commission has deemed the proposed action to approve the petition as a type 3 proposal under Wisconsin Administrative Code, section PSC 4.10 sub 3. In their responses to the petition and at the pre-hearing conference, petitioner opponents raised as an issue for hearing whether the commission should prepare an EA or EIS with respect to this proposal. However, petition opponents have offered no evidence to indicate that the preparation of an EA or EIS is warranted. So my question is, therefore, provide a brief statement on the petition opponent's current position on the matter.
And our position is that we will be addressing this issue in brief as a matter of law. We believe the commission's decision in this regard is contrary to law and commission precedent.
Okay, so I just wanted to make sure I understand, because my impression at the pre-hearing was that I would be receiving evidence showing that there's a matter of fact, there's a reason why an EA or EIS is warranted. And that's based on that rule that I cited. So is that the case now, that the petition opponents do not have any facts to show that an EA or EIS is warranted?
We did not present evidence on that issue. That's correct.
Okay, so it's strictly a legal issue. Okay, so that was one of the reasons why we went through the evidentiary hearing process. I wanted to make sure that parties were given that opportunity to present that kind of evidence. All right. So, okay, so now we've dealt with all of my preliminary issues. I believe we're ready to call our first witness.
MREA calls Nick Hyla.
Okay, and in the room or on screen?
On screen.
All right. Get me the record for a second.
Morning, Your Honor.
So I'm gonna pin you to the screen. That's a term of art here with Zoom. And hopefully we see you here. And we're hearing you okay. So let me swear you in. Raise your right hand and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. So we have your attorney take it away.
Morning, Mr. Hyla. Can you state and spell your last name for the record?
Hyla, Hylla.
Mr. Hyla, did you prepare and cause to be filed in this docket 7 pages of direct and 11 pages of rebuttal testimony along with 2 exhibits?
Yes, I did.
And do you have any corrections that you know of to any of those documents?
No, I do not.
And if I asked you the questions today that appear in your testimony, would your answers be the same as appear in the pre-filed testimony?
Yes.
Mr. Hyla, by way of some sir rebuttal to the last round of pre-filed testimony. On pages 1 to 2 of Mr. Adams' sir rebuttal for the municipal utilities, he reports a dispute that third-party finance distributed energy resources be sized specifically for host customer loads or provide power only to the host customer. Do you have a response to that testimony?
Just a second, can you just give me that site again?
It would be Adams' sir rebuttal.
What?
Pages 1 and continuing on to 2.
Oh,
I do.
okay, go ahead.
Mr. Adams' testimony refers to a consumer protection concern that an oversized system will not provide a customer with promised bill savings, and to an interconnection issue related to impacts on the distribution system. I note a number of problems with his analysis. First, sizing is generally duplicative of most utility tariffs. For example, Wisconsin Electric CGS-NM and Wisconsin Public Services PG4 tariff required the generation to be sized to the customer's expected load requirements. Xcel's PG1 tariff requires the resources to serve only the customer's premises and to offset the customer's consumption. Second, he does not identify any actual oversized system. Instead, he refers back to discussion in his direct testimony about one customer who did not realize bill savings. There's no indication that the reference system is oversized. Third, the distribution system impacts is really an interconnection issue related to PSC 119, not this docket. And fourth, neither the consumer cost savings nor the interconnection issue is specifically a third-party financing issue, and would equally impact a system that the customer purchased directly. And I guess finally, Mr. Adams' logic is that an oversized system means that it's providing power to the public, which is incorrect. Excess generation from an oversized system is sold to the utility, not to the public as defined in the tariff. So power sales to a utility does not make an entity a public utility.
Thank you, Mr. Hyla. Can you explain how MREA ensures that distributed energy resources for the school project that are referred to in the petition and your direct testimony are sized to that customer's load?
Yes, to ensure cost recovery from the investment on our side, as well as electricity bill savings to the customer, the school in this instance, the system is designed and sized to maximize financial returns to the host customer. Though this is dependent on the utility tariff, the host customer electric use of the physical site, the strategy is typically to avoid purchasing, more electricity. It's to reduce the customer's electricity use and avoid purchasing electricity to the utility, not to export power on any given month. To do this, we analyze a minimum of 1 year utility bill savings, as well as any detailed electrical usage that's available. We also conduct a site assessment in line with technical training standards that we offer at MREA and have been offering in our accredited training programs for the last 30 years. We also conduct design and modeling over the 25-year warranty life of the system, which we use publicly available tools from the National Renewable Energy Lab to do. And then commonly investor-owned utilities in Wisconsin net energy bill on a monthly basis. So the PV system sizing is meant to limit the amount of overproduction on any given month. And in this way, the system is reducing purchases from the utility at the retail rate and avoiding export to the utility at lower rates as defined in the tariff.
Again, Mr. Adams also refers to an incentive for third-party finance energy systems to be oversized. To your knowledge, is there an incentive to oversize a third-party finance distributed energy system?
Not that I'm aware of. Generally, production in excess of a customer's consumption within the billing period for net metering or instantaneous use outside of net metering is priced at an avoided cost rate that is significantly less than a retail rate. And so there's really no incentive to produce more than the host customer's level of consumption, as it's in the system owner's interest to ensure that that customer is receiving benefits so that they can pay off the investment.
I'm sorry, so that they can.
Oh, pay off the investment.
Thank you.
And turning to this rebuttal testimony by Mr. Root for CFC. In that testimony, Mr. Root refers to a letter from Wisconsin DOT Secretary Thompson, the United States Department of Transportation, that in that letter refers to a PSC position on public charging for electric vehicles as a public utility. Do you have a response to that testimony in that letter from Mr. Root?
I do. Public charging of electric vehicles is different from distributed energy resources described in our petition. And I'd like to note the following differences. The first, public chargers are located where they will be used by any and all customers who have an electric vehicle and seek charging. They are intentionally located in high traffic areas and open to all. In contrast, third-party finance distributed energy resources, including the ones in MREA's petition, are dedicated to a single customer who hosts the equipment on the customer's property and is the only user. EV chargers do not involve a customer-specific written contract prior to charging. Typically, there's no agreement other than that of an implied agreement to pay the price posted for the charge. EV chargers are intentionally designed to universally connect to any or most electric vehicles. The DERs and MREA's petition are specifically designed for the physical characteristics of the host customer's property and electrical equipment. EV customers can theoretically rely exclusively on public chargers without being a customer of a local monopoly utility. The DER customers in MREA's petition will all remain electrical customers of the local monopoly utility for supplemental power service. I'd like to note that while I think there can be a debate about whether EV chargers have any relation to public utility regulation, that is a different analysis and different question than the facts that we've presented in our petition.
Okay, thank you, Mr. Howell. I have no further questions for this witness.
Okay, any other cross?
Yeah, sure.
I'm sorry. No, any, the witness is available for cross. And let's see, we have WA, any other cross besides them? No? All right. Go ahead, Attorney Jackson.
Good morning, Mr. Hyla. My name is Brad Jackson. I represent the Wisconsin Utilities Association in this matter. I first have some questions for you regarding the discovery that WA served on MREA. And in particular, I want to start with MREA's response to the WA first set of discovery requests. You have access to that document?
Yes, sir.
Let me. Oh, so which one are you gonna?
First set, 446335.
We're where we need to be.
All right. Mr. Heiler, you signed these responses, correct?
Yes, sir.
Yes, sir. I'd like to turn your attention to your response to 1 WA RFP 10. Fortunately, there's no page numbers, but it's fairly deep into the document, maybe four pages from the end.
Page 16 of the PDF.
Have it on the screen there.
Okay, so number 10. We asked you for any third-party ownership contracts that MREA has with any of the customers referred to in your petition, and you answered that you had no such contracts, correct?
Correct.
You just testified, though, that the system that you've designed for a school has been designed to meet the school's load. That's not the subject of a contract?
It's the subject to a negotiation leading to a contract.
Right. Is there any particular reason why you do not have a contract yet with that school?
We're petitioning the Public Service Commission for legal clarity.
And is it still true that you have no such contracts with any customers?
Yes, that's true.
Next one down, number 11, we asked you for any form contracts that you intended to use with customers, and you answered that you have no such form contracts, correct?
Correct.
Is that still true?
It is.
And number 12, we asked you for any form contracts that your members intended to use with customers, and you answered that you had no such form contracts. Is that correct?
That is correct.
Is that still true? Is that still true, sir?
Yes.
All right, thank you. Now I'd like to turn your attention to MREA's responses to WA's second set, and that's PSC reference 448610.
It's on the screen.
And I'd like to ask you first about 2 WA INT 3, which is third page. There we asked you what range of options would be made available to DER customers, including the term of the contract, power release pricing, and maintenance terms and conditions. You did not provide any of that information, did you?
We provided what's exhibited on the screen here in our response.
Well, you said that customers you contract with would remain customers of the utility, and to the extent the request asks information about alternatives to MREA provided DERs, you weren't aware of contract terms, you did not provide any information about term of the contract, power lease pricing, or maintenance terms and conditions that MREA would offer its customers, did you?
Objection, asked and answered.
Overall,
Clarity on the question, can you repeat?
read it back.
Questionable, you said that customers you contract with remain customers of the utility, and to the extent the request asks information about alternatives that MREA provided DERs, you're aware of contract terms. You did not provide any information about term of the contract, power lease pricing, or maintenance terms and conditions that MREA would offer its customers, did you?
Well, we weren't asked that question. The question was to provide a range of options. We're not aware of the full range of options, so it made it difficult to respond fully.
Well, you're aware of the range of supply options MREA would make available to DER customers, are you not?
Well, no, not necessarily. We're aware of some options.
But
or
you didn't provide
some specific options, but the full range of options that we might provide, no.
I'm sorry, I don't see the word full in the request. I'm, again, even though you are aware of some range of supply options available to DER customers, including term of the contract, power lease pricing, and maintenance terms and conditions, you did not disclose those to us, correct?
We did not in this response, no.
And in the answer to 2WA-INT-4, you state MREA is not aware of any specific contract for DERs. Does that remain true today?
I can't, on the screen, I don't see the full question. There we go. Are we on 4?
Number 4, yeah, the response.
So off the record, I think there's a little delay between what we see and what he's.
Okay.
Understood. Okay, thank you.
Can you repeat the question, please?
I asked you to confirm that in the response to that one, you stated, quote, MREA is not aware of any specific contract for DERs, end quote. And I asked you whether that is still true.
The request is what it is. There's more to the response than council.
All right. All right. MREA is not aware of any specific contract for DER, so cannot describe the privacy assurances. Is that still true today?
Yes.
If you have no contracts or form of contracts, and can produce no contract terms, power lease pricing, or maintenance terms and conditions that you would use with customers, what is the basis for your testimony, your direct testimony at page 3 about the differences between third-party ownership leases and PPAs?
Okay, let me get to that. You in the right spot?
Further up the page, please. It starts line 7. goes through line 16
On page 3.
on page 3.
So
Okay.
I think as we've established, the MREA does not have a signed contract with the host customer at this time. And in general, didn't want to expose ourselves to legal liability. But the basis for the testimony here, beginning on 7, MREA will own DR equipment either exclusively or together with another third-party financing entity. And the following 6, I believe, bullet points, 7, 6, 7, 8 bullet points are the general framework for contract negotiation around power purchase agreement.
I'm just going to interrupt. Am I in the right place or?
I'm not aware, you're referring to bullet points, I'm not aware of those.
So
Page 3 of your direct.
page 3 of Ala Direct. There's a question on line 3. What is third-party financing for DERs?
Well, I guess I'm referring to in my direct testimony on an answer to the question of what defines DERs. We've listed 1, 2, 3, 4, 5, 6, 7, 8, 9 bullet points. That's in the direct testimony, in our rebuttal testimony, as well as our direct testimony. If you look at the direct testimony, those are laid out on page 4, starting on line 20. And that's the basis for an agreement for a third-party power purchase agreement as laid out in the testimony. The specific contract terms, we enter into good faith with a single party when and if there is determination by the Public Service Commission and an interpretation of existing statute that these types of arrangements would not expose us to legal jeopardy.
Okay. I understand that you've laid out these bullet points, but I guess I'm still asking what the basis is for your testimony on page 3 about the differences between a DER lease and power purchase agreement, because I don't see on pages 4 and 5 the words lease or PPA.
In general terms, you're asking the difference between a lease and a power purchase agreement?
I'm asking what the basis is for your testimony about the differences. If you don't have any contracts and you don't have any form of contracts and apparently don't have any contract terms that you're willing to share.
The difference between a power purchase agreement and a lease within the contract terms, a power purchase agreement, the customer payment relates directly to the utility bill savings. And so in general, in a power purchase agreement, the onus of operation and maintenance for the solar PV system is on the owner, on the lessor or the owner and the site host. The payments are related to electricity bill savings. Whereas in a lease, the lease payments are relatively fixed. Usually the site host is responsible for operation and maintenance. In the MREA's general contract intent would be a power purchase agreement in which we would provide the operation and maintenance of the system. Those arrangements, I guess, are more acceptable to some customers than others. It's really a customer choice.
Okay, and the basis for that testimony you just gave and the testimony in your direct is not based on any contract or form of contract or contract terms and conditions that MREA possesses?
We currently do not have a contract with any customer.
That wasn't my question. It kind of wasn't. Thank you.
Go ahead.
I asked a question. It's pending. I didn't get an answer to that question.
All right, let's
Could
read
you-
it back.
Could you answer my question, please?
Yeah, if you can repeat it, I guess.
Read it back.
Question, the basis for that testimony you just gave and the testimony in your direct is not based on any contract or form of contract or contract terms and conditions that MREA possesses?
That's not true. We do possess contract terms that would form the basis for an executed contract with a customer. But at this point, we do not have a signed contract.
If you
We are in
have,
possession, however, of contract terms that generally lay out a power purchase agreement contract with a third-party customer.
isn't that what you would refer to as a form of contract?
Maybe I'm misunderstanding the question. The question in your discovery was for us to supply the full range of contract options. We did not do so because we weren't in possession of the full range of contract options.
In the first set, RFP 11, we asked for forms of any contracts that MREA intends to use to contract with host customers for third-party ownership arrangements. And I think what you just described is precisely that. Where are we misunderstanding each other, Mr. Hyla?
Stop, can I get that reference off? Okay.
1 WA RFP 11.
You're in MREA.
Produce, so your question, the first is produce forms of any contracts that an MREA intends to use to contract with host customers for third-party ownership arrangements. At this point, like I said, we do have contract templates, but we don't have executed contracts and they haven't been negotiated with host customer. If that's of interest to you and responsive to this request, we can provide that. For the second, produce forms of any contracts that MREA's member intend to use to contract with host customers under third-party ownership arrangements. We don't have any documents responsive to that request. We're not in possession of member contracts or don't know how their intentions to use contracts.
Yeah, and I was asking you about the form of contracts, and we would be interested in seeing those. Would you be willing to produce those now?
Is there jeopardy on our side in sharing our contracts, understanding the history of some incumbent utility disposition towards third-party financing, meaning we've explicitly seen a utility deny an interconnection agreement And we also know that utilities have projects that they are offering in the same, to the same customers through their, so I guess maybe this is a question for my counsel.
Well, what I'm hearing is these might be something that would be filed confidentially and for attorney's eyes only, subject to certain restrictions limiting competitive interests. So, I mean, that's one option.
Let's make a record here. So we interpreted this as a request for form contract. Like a fill in the blank form contract, and there is, to my knowledge, there is no. I think council's using the word forms of means something slightly different, which is as the witness said, bullet points in as part of an ongoing negotiation that have been discussed with a potential customer. And those do exist, but that's not what that's not how we interpreted this. So if the request is for terms of not yet executed contracts, so negotiation terms. You could provide them, but it would be subject to a request for protective order and probably the attorney's items.
Okay, but what I heard him say was he had templates of contracts, and I don't know how you could read number 11 any other way. But having said that, yes, we would accept receipt of these contract templates under confidentiality, and we're willing to keep them attorney's eyes only and not shared with our members.
All right. So let's mark that. MREA Hyla 3. I think we have a good enough description prior to my marking that exhibit. So that'll be filed under confidentiality, a request for confidential handling treatment on earth and served to who now?
WA, care of me.
Okay, so WA, attorney's eyes only.
Correct.
Any other parties? Actually, really what we should say is which party should not receive this document. That would be the easiest or the most appropriate way to decide this. I'm assuming utilities, is that part of the conflict, competitive conflict? So no.
Right, so it would be none of WA's members, which would exclude the utilities themselves from receiving it. Would that include, I don't understand the connection between the munis and WUA, but it would include them as the utilities as well, and the co-ops in there. I guess it could be WECA, but then not with them.
That would be fine. WCA would accept it on the same terms that WUA would. Okay. Similarly, forward could do the same. Forward does have
I'm sorry, similarly,
fair rates for Wisconsin Maryland. Same would be attorney's eyes only. Share with the members.
Same would be the case for.
And
that would also, so with respect to the munis, that would also be the case. Attorney advice only.
so the munis, it would be,
Municipal utility.
but what about the three entities? So GLU would be,
Yeah, Great Lakes Utilities, MEUW, which is the trade association. And WPI.
So we would say not WPPI since it's effectively like utility.
and GLU would not fall under that category.
Glue has the same status as WPPI.
I'm sorry, can't hear you.
Glue is a municipal electric company, just as the WPPI energy.
So we limit it to MEUW.
Correct.
Yeah.
I just have a quick question, because as an attorney that works for both utility and WUA, I think attorney's eyes only is sufficient protection for any contract here. You don't need to, we're not going to share it with the business folks. So I don't quite understand why we're parsing it by parties if it's already their attorney side only protection.
Well, because there's other parties besides the electric provider, so.
Well, that's what I mean. So if it's given to the attorneys of the parties in this case, that's should be sufficient protection for a contract that's with the customer. So
yeah,
just want to make sure that we're able to share with in-house counsel that we have it as attorneys for the utilities, and our in-house counsel have it as well. So they're also under attorney side open protection.
well, I think we're providing it to UWA attorneys, not the utilities council. That's what
My
we,
understanding of attorney's eyes only, it's attorneys of record for the party it's provided to, doesn't, it's not an umbrella that anyone who has a JD gets to see it.
attorneys of record, sure.
Well, right. So I think we're both listed as attorneys of record for WA, WPSC, and Wisconsin Electric, and Keith Phillips is listed as attorney of record for WPSC and Wisconsin Electric. And so in terms of parsing the parties, the attorney's eyes only to the attorneys of record in this case would be sufficient protection. I just want to make sure that it's clear.
But not to the utility, I guess. So not to Attorney Phillips is what I'm saying, because she is affiliated only with the utility.
Well, I think she should be allowed to see it.
She should be.
She's an attorney of record in this proceeding.
Okay.
Attorney's eyes
All right.
only is a sufficient protection for whatever
Okay.
thin reed protection it
If
needs.
parties agree to that, that's fine with me. All right, so we do have parties that are not represented by attorneys. So in case of those parties, any objection to having them get the terms and conditions?
I don't think we have the protective order is attorney's eyes only, but we need a supplemental protective order for parties that don't have attorneys. I don't know if they want it. If they do, I guess we can create a confidentiality agreement for those parties separate.
Okay, well, I guess we just offer it to them if they want. Okay, so we can have that in 3 days after the hearing. Okay, so we'll get HILA 3 submitted within 3 days after the hearing, the form contract, terms, conditions, attorney's eyes only, parties of record in the case, and other parties not represented by attorneys, subject to confidentiality agreements that they enter into with MREA, should they do so. Okay, anything else with that? Here, any further questions?
Yes, I have some additional questions. Mr. Hyla, you've indicated that MREA intends to install and own DER systems at customer sites, correct?
Correct.
And those would be facilitated by contracts with the customer that could be, take the form of either a lease or a PPA, correct?
Just a PPA.
So MREA does not intend to pursue the lease option? Is that what you're saying?
No.
Yes, MREA does not intend to pursue the lease option.
We do not. intend to pursue the lease option.
Thank you, okay. Now, under the PPA option, MREA would own the system and would therefore be entitled to all of the tax benefits associated with the system, correct?
That is, we're technically yes, but we're with the passage of the energy tax provisions in the Inflation Reduction Act, there is some question of IRS guidance pending. But in general, yes.
Okay, yeah, let me limit my questions to the customer being a taxpayer as opposed to a nonprofit, if we could. And in that case, the owner of the system under a PPA would be entitled to the tax benefits, correct?
As generally understood, correct.
Now, as a nonprofit, is MREA able to take advantage of investment tax credits and accelerated depreciation?
In our original arrangements, no.
All right. So in these types of arrangements, what entity would get the tax benefits?
No entity would potentially.
Is that how you're designing your arrangements, that these projects would not be supported by any federal tax benefits?
Under our current arrangement, we have 3 projects fully funded. So the only cost to us is the continued operation and maintenance. So tax credits were not a part of the project design requirement. Again, though, after the passage of the Inflation Reduction Act, some of those tax credits are now available as direct pay, which would substantially change the kind of relationship between parties, let's say.
All right, so the 3 projects you've mentioned, are those all with customers who are themselves nonprofit?
Yes.
All right. Returning to your direct testimony, page 3, and I believe you mentioned this in answer to one of my questions. You state that under a power purchase agreement, the amount of payment each month depends on the amount of solar electricity produced, correct?
Partially correct. Depends on the amount of utility bill savings realized, which depends on the amount of solar electricity generated.
Do you know how a payment under a third-party lease is structured?
I don't have professional experience in structuring leases, but I can discuss in general.
Would you agree that the different, I'm sorry, were you going to continue? Sorry.
My understanding in a lease relationship is that a lease payment is fixed, similar to like a car lease, and is independent of the monthly utility bill savings or electricity generated. And another distinguishing contract term would be the responsibility of operation and maintenance of the system. So I guess to be clear, in a power purchase agreement, if you have a structured PPA and the PPA contract states that the payment is related to some portion of the utility bill savings and the operation and maintenance is the responsibility of the owner, that means the owner doesn't get paid if the system's not working or not performing financially as described. And so it's a form of customer protection, as in leases, though they have forms of consumer protection within the lease contract do not generally relate their payment structure to utility bill savings.
Now, Your Honor, I intended to ask Mr. Hyla some questions about the exhibit that Mr. Heiser would have offered. I understand that's been stricken. Do you want me to make my offer of proof and go through that cross now, or await the commission decision?
Yeah, we'll make an offer of proof. It'll be a separate transcript volume and will be given to the commissioners only if they reverse my ruling. So we'll start that
May I
now.
proceed?
Okay.
Mr. Hyla, had you reviewed the testimony that we offered from Edward Heiser in this case?
Yes, that was posted. I did receive an exhibit this morning that I have not reviewed.
So you reviewed Mr. Heiser's testimony, but not his exhibit that he
I believe
offered?
so, yes. Four four nine 415.
Yeah, I'm questioning my decision to proceed here.
I mean, this is just an exhibit. No, I have not reviewed this exhibit.
And you testified that it's MREA's intent not to pursue third-party owned arrangements through leases, but through PPAs, correct?
Correct.
All right. I will not make my offer of proof, and I will have no further questions. Thank you.
All right. Thank you very much. I believe Commissioner Nowak, did you have a question?
Mr. Hyla, I had a question for you on the discussion you had with Attorney Jackson regarding what we've now learned, the forms you have for leases that will be turned over.
And let me just check. Can you hear the question?
Yes, yes.
Go ahead.
You stated during that answer that the final contract, it depends on the intent of the parties that you enter into a contract with. Because these are fact-specific situations, can you elaborate more on the intent and how that may enter into changes in the contracts that we may see, or you may see?
Yes, one clarification is we do not have forms related to leases, but we do have forms related to power purchase agreements, since I think the attorney was making a distinction there. So I'd like to make that distinction again. So that the facts as laid out in our petition would not be altered. There is some surely variability in contract. For example, some contract variability might be in the rights to purchase as laid out in the contract. In some contracts, that right to purchase persists from contract signing. So it could be specifically in our case, for example, where there's no tax liability, no tax appetite on the table. It could be that we enter into a contract and the site host can purchase at fair market value at any time. And also the contract terms vary because of the passage of the Inflation Reduction Act and the availability of direct pay tax credit. It also may be in our particular situation that there is a local donor that could be an interested party in the contract. And then one specific aspect of our contract is the dedication of revenue towards scholarship programming. And so some question becomes, where are those funds kept? How are they used? What are the terms around those funds? You know, the intent of the parties in contract negotiation does not change the form of the ownership of the structure and the 9 bullet points that we've laid out in our case, but does address kind of the attribution of revenue, the ability to purchase. There's always some negotiation around site access. For us, it might be access to utilize the systems for workforce training. And so there are negotiations that need to be continued.
Other cross? I think you probably want to sit up at the table. Okay.
Richard Heineman, Municipal Group. I'd like, if I may, can you hear me, by the way?
Move it a little closer.
And that mic is on. They're a little sticky. Yeah, there you go.
You went through some server rebuttal earlier, and I really would like an opportunity to just explore that a little bit. If you wouldn't mind, it was in reference to Mr. Adams' server rebuttal testimony.
If you could speak up a bit, it would be helpful.
Can you hear me now? Is that better?
A little better, thank you.
Okay, thank you. So Mr. Heineman, counsel for the municipal group, earlier at the outset of your appearance today, you provided some server rebuttal in response to Mr. Adams. And I was looking to explore that a bit. Can you hear me now?
Yes.
Yes. If I understood your server rebuttal correctly, the gist of what you were suggesting was that Mr. Adams' analysis was flawed in the sense that he had asserted that there were questions about the sizing of DER, third-party owned DER systems and transparency associated with that, correct? That was the issue that you were concerned about in your server rebuttal. Is that correct?
Generally, yes.
And if I understood what you were saying on the stand, your assertion is that essentially there are no incentives on the part of third-party owned systems to oversize the system, and that any excess energy that might be produced by the system is sold to the utility under net metering tariffs. Did I understand that correctly?
I mean, generally, yes. I wouldn't say that there's absolutely no incentive. I mean, I can think of, people act outside of their own self-interest. So in general, if the intent of the contract is to be paid, then oversizing a system increases the costs and reduces the savings for the customer, which reduces the payment appetite. So in general, there is no, for example, here's an example of somebody that could oversize the system. Maybe they're just chasing the tax credit. So you increase the cost of the system or the size of the system, the tax credit increases. However, it reduces the benefit to the customer, which reduces their appetite to pay. So in general, I would say, and in my experience, this is not an issue that I've seen occur in these arrangements. And you can look at the state of Iowa, where this has been legalized. And this is not generally, and I know of no specific instance where this has occurred. That's not to say that there is no incentive.
In the case of the systems that you're aware of with respect to MREA, are there instances where the anticipated payments from the incumbent utility under the net metering tariff factor into the analysis that you undertake or that your members undertake when they design?
That is the basis for the analysis.
Wait, hang on, one at a time.
I'm
Yeah.
sorry.
Undertake
ahead,
when they
Melissa.
design the system.
Is that an important component of the system design? I didn't mean to interrupt you. Go ahead.
Yes, so functionally, in any given third-party arrangement, the basis for the system design and sizing factors the electricity usage of the host customer, as well as their physical site and the utility tariff. So in Wisconsin, for example, most utilities have a net energy billing tariff that's trued up monthly. And so if the system is sized in a way that it overproduces solar production above and beyond the customer demand in any given month, then all of that overproduction is valued at a local marginalized price, which is significantly reduced from the retail offsetting present in net metering. So those conditions restrict the financial right sizing, as we call it, of the system to the customer's electricity production, because systems that are bigger will overproduce and be more expensive, and thus and recoup less of their production in the retail rate as instead of the local marginalized price. So yes.
And it's also the case that for systems that are larger than a certain size under most utility tariffs, net metering may not even be a component. So
correct.
There are many tariffs that are greater than 20 kW, for example. And so those larger systems may be subject to other pricing considerations, correct?
Correct. So in that case, you would need, if you're sizing a system above the net metering limit in any utility territory, a project developer would need more granular energy use data to ensure that the system is operating at any given time under the or at or near the level of consumption, because anything that's exported would at any given time in this kind of instantaneous situation would be valued at local marginalized price. So again, in that context, the energy use profile of the facility is used for system sizing.
And in such an instance, would there be a benefit to the party, the entity that was designing the system, to have a discussion about that energy usage profile from the outset with the incumbent utility, for example?
I guess, yes, if there's a trusting relationship with the utility. At this point, I don't think that all parties are operating in a trusting relationship, and with the concern that as utilities become aware of projects with, say, schools or hospitals or municipalities, their interests as expressed have been to either or both to warn the host customer that they're entering into a relationship that is potentially illegal, and or to provide their own service as a replacement. And so I think in an instance where they're, like, let's just say if there were to be a declaratory ruling that interprets these set of facts as not subject to utility regulation, then I think that it would be much more likely that developers would work more closely with the utilities to ensure that they have all the most accurate information about the energy usage and the tariff to advance better projects.
I want to get back to a reference that you made, I believe, in your source or rebuttal to PSC 119, and just ask a simple question, and that is, if there were an instance where there was some disincentive on the part of the incumbent utility to purchase the excess energy that was flowing back onto the system, would MREA, in appropriate circumstances, or its members, in designing that system, would they be willing to impose technical controls in order to prevent the backflow onto the utility system, so that there would be little or no need to purchase that excess energy?
Well, Jack is vague and compound. I couldn't follow the question, so I'm guessing it was a witness to you.
Okay, fair enough. I'm recalling your rebuttal testimony in which you were responding to Mr. Adams, in which you suggested that there is the ability, there are technical controls that are available to prevent backflow onto the incumbent utility system, right?
Again, this is a reference to the pre-filed rebuttal and the source rebuttal.
This is a reference. There's a statement in Mr. Hill's rebuttal testimony to that extent.
And then I've asked them to pull that off so we can have that record.
Okay, so off the record, so I do have backflow appearing on the screen here. It's rebuttal, Hilo's rebuttal, page 10. Is that close to where we're, do you have any other response to specific direct testimony?
I'm ultimately going to ask a very simple question.
Yeah, just want to be on the same page.
Yeah.
Line 15.
No rebuttal testimony. Yeah.
Let me know when we go back to the record.
Page
10.
Yep, page 10, line 50, that's correct. Yeah, the testimony reads.
Okay, so back on the record?
Yes, back on the record, thank you. Mr. Adams does not support the assertion that backflow is inevitable. It is not, since limiting devices are available to prevent backflow. So my question is that in certain circumstances, with respect to the design of these systems, would MREA or its members, where appropriate, be willing to agree to impose those direct controls in order to prevent backflow onto the system?
I mean, if
In order
in a
to prevent
hypothetical.
backflow. Yes, it is a hypothetical.
In order to
then
prevent,
Backflow onto the distribution.
This has occurred in Wisconsin. It hasn't been, I think the context of your question is a willingness. And in certain situation that I am very familiar with, it was a requirement of the utility that this happened. But what I will say is that with the current technology available, these DER systems, when coupled, for example, with smart inverters, demand response, energy storage, and energy monitoring, can and probably should manage their load and export to the for the highest value of the customer and the highest value of the utility system. And in that context, if a rate, for example, had a time of use rate that reflected times of the day when utilities have high cost power, then the systems could only export at that time, or at least dramatically reduce load at that time and shift load. And so I guess the short answer is yes, it's possible. And that yes, under certain circumstances, I think most of the industry would be predisposed to be the best possible utility customers as possible, and the technology does exist. I think the caveat is the justification of need, because I know that there is can be an incentive on the utility side, again, being a competitive actor in the space, and seeing distributed energy resources as a threat. They can have an interest in increasing project cost without justification. So I think, as they say, trust but verify. So I don't know. I would say yes. The short answer is yes, I guess.
That's it. No further questions.
Just wanted to clarify with you, with Ms. Hala, your answer that you just gave, was it related to only net metering systems or bigger systems?
So I think it's likely could be both. And so if you look at any given tariff in a net metering situation, the ability for a host customer to fully utilize the production of their solar PV system to offset the retail rate can be a justification, financial justification for limiting any export. Because the intent is to try to maximize the value of each kilowatt hour produced, and in a net metering context, that value of production is, when the net energy billing is on a monthly basis, is to make sure that all of that production is coming off of your utility bill and not being exported at local marginalized price. Outside of a net metering context, there is a greater justification often because of the need to not export electricity at any given time, because that reduces the value of the kilowatt hours of electricity produced. And for larger systems, for certain customers, there is also the demand charges, and that's not something that is typically incorporated in systems financial performance. No, necessarily should it be, but in the context of applying kind of limiting devices and energy storage, it's possible, and in modeling and likely in practice, that energy storage and DERs can be used to effectively reduce times of peak usage. And so I think that there are many scenarios that this is possible in the future and currently. And so I think that generally the answer is yes.
Okay, thanks. Any other cross? I'm not seeing everyone on Zoom, so I'm just going to look through the list here. No one else is on screen. I'm assuming no other questions. All right, any redirect?
Well, just one redirect, Mr. Hyla. In response to Mr. Jackson's questions about MREA's current plans being limited to offering PPAs if clarity in the law is achieved. Does MREA rule out the possibility of offering leases in the future should circumstances change?
No.
Nothing further. Thank you.
All right. Okay, well, seeing that, you're excused. Thanks very much.
Thank you, Your Honor.
And all right, great. So we do have the other witnesses subject to affidavits, but we have one witness that we were going to call. We can probably take care of that witness now.
That's good, thank you, Your Honor. We would call Commissioner Simon on behalf
Good morning. Who swear you in? You swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, have a seat. It may be cold because it hasn't been sat on in years. Apologize for that. Okay, go ahead.
Commissioner Simon, would you please state and spell your last name for the record, please?
Simon.
And your first name?
Oh, I'm sorry. Timothy, Timothy, Allen, Alan, Simon, Simon.
Thank you. And Commissioner Simon, did you prepare and cause to be filed direct and rebuttal testimony on behalf of the Wisconsin Utilities Association?
Yes.
And did you prepare and cause to be filed 10 exhibits referenced in that testimony?
Yes.
And if I asked you the questions in your direct and rebuttal testimony today, would your answers be the same as were filed?
Yes.
And are the exhibits subject to the corrections in the offered evidence report true and correct to the best of your knowledge?
Yes, to the best of my knowledge.
Commissioner Simon, I would, that's all the questions I have for you. If anybody else has questions.
All right, any cross? No, check Zoom. No, all right, that's it. Thank you very much. You're
Thank you.
excused. Okay, so any, oh, yes, go ahead.
Question.
Yes.
When are the affidavits due?
Okay, well, according to the schedule, 3 days after the hearing date, 3 working days, as well as revised testimony, the affidavits, and there's one other thing, any exhibits that we received at the hearing but have not yet been filed. So, okay, so that's some of the deadlines. Any other questions of the process going forward? Okay, I did want to, not to bring up the dead here, I did want to bring up one point on the motion to strike. I think Attorney Jackson did mention the difference between this case, the DR 105 and DR 106, because in DR 106 there have been no objections to the receipt of the Heiser testimony, and because there are no objections that will be received. However, the difference between those 2 dockets is obviously that there was a timely motion filed, which I then acted upon. So just want to make that clear. So at this point, anything else?
I have a clarification to be off the record. In the
You want to be off the record?
off record.
Okay, go ahead.
In the pre-hearing conference, conference order, facilitating matters, there's a reference to applicants having someone available during public sessions to answer questions. I don't interpret that to include us, but it could be corrected.
I suppose it's not really the intent to have that requirement in this case. Usually it's meant so that customers can approach a utility for bill questions, or, is this line going through my property, that kind of thing. So, yeah, let's get on the record then. It just makes it clear. So there was a request from MREA to clarify the requirements in the facilitating matters order to have applicant representatives be available at the public hearing session. And I can waive that requirement at this point. It's not really the intent of the requirement to have the applicants in this particular type of case appear at that hearing. Right. Okay, that's all we have then. Thanks very much. We're adjourned. So many things to do now. Can't even begin.